Sir, from the UPSC perspective, UPSC exam perspective, as well as from the perspective of common man, when we take the cases of legislature, executive and judiciary, I have noticed that judiciary is becoming more powerful and the role of judiciary is also becoming increasing day by day. So what are the, like many judgments, recent judgments also, they are transforming the lives of even common man. What what are the three, can you just list three landmark judgments that you think that have transformed the lives of so many people?
Well, that probably requires a data search of the impact of judgments on individual lives or collective lives. But we do have anecdotal evidence. As lawyers, we have some understanding and narratives of how judgments have affected lives of people. Now, a judgment like Kesavananda Bharati, for instance, that gave what at that time was a contested idea of the basic structure of the Constitution, is something that permeates our entire law, right? The basic structure of a Constitution that is immutable, that cannot be amended, cannot be changed even by 2/3 majority of Parliament, gives you a kind of certainty and permanence in concepts that combine to form the Constitution. Now, a lot of people said at that time, people, particularly those who followed the British tradition, where Parliament is supreme and Parliament can do anything it pleases, and people thought that this was infringement of Parliament's sovereignty, and the courts were unnecessarily expanding their own areas of operation. But I think over the years, people have understood that, my God, if you didn't have Kesavananda Bharati and the idea of basic structure, then the Constitution would be something that could very easily be manipulated. Now, ultimately, historically, you might say that permanence in a particular format is good or bad, that history will finally tell. But the stability and certainty in law, in constitutional understanding that we have today is because of Kesavananda Bharati. And obviously, this permeates into every decision that we take in this country and every legislation we pass in this country, therefore inevitably affects the rights of people. So that's one critical judgment. Another, and I'm sure Gaurav will agree with me, another critical judgment is Maneka Gandhi, which was on Article 21. There was debate at the time of our Constitution writing whether the due process clause, substantive due process clause as it's called in the United States Constitution, should be put into the Indian Constitution, and consciously some reluctance to do that was reflected in the language that was used. So there was due process, but not substantive due process. In other words, you could not take action against a person unless there was a law giving you the right to take action, but no further. What Maneka Gandhi did, it was introduced and said, not only should there be a law, but that law should be just, fair and non-discriminatory. So some people would say that this is rewriting of the Constitution. Some people would say this is a true discovery of the truth of the Constitution. But certainly in practical and pragmatic terms, what it has done is given a huge wall of non-interference against the government, against the state, vis-a-vis the individual. So the individual today and the rights of the individual are far more protected than they were, in a sense, before Article 21 was explained in the manner in which Maneka Gandhi has explained it. I mean, it's so difficult to choose, but on the issue of affirmative action, for instance, I think Indra Sani is a terrific case. I don't think that's the end of the story. The story goes on. The story of reverse discrimination, or the story of positive discrimination, or the story, as it were, of reservation, etc., is not over yet, because the courts are dealing with it again and again all the time. But essentially, equality explained in terms of substantive and real equality, not just in the verbal equality or the equality in phrase, but equality in substance. So that two people who are not functionally equal in the marketplace should not be treated equally under the pretense that they are equal and therefore they've been treated as equal. Those who are unequals must be treated with knowledge that they are unequal, and therefore special preference must be given to them. And this is how we have tried to revolutionize our society by ensuring that those who suffered historical disadvantage were, like the American jurisdictions and the American decisions on equality and reverse discrimination, Bakke being that famous case of admissions, etc. Similarly here, we have done this for those who deserve, according to the Constitution and the Constitutional Assembly, and according to legislatures from time to time, people who deserve to be given affirmative action and support, like the Dalits, like the tribals, like disadvantaged groups, etc. And they've this whole discussion happens in Indira Sawhney, and that's become a landmark judgment as far as affirmative action is concerned.
What you mentioned is really right, sir. In the sense that unequals should not be treated equally. That was put in the Indira Sawhney case. And regarding the basic structure doctrine, that emerged as a landmark judgment, in the sense that the court invented a new mechanism by itself. So in these cases, to an extent, we can say that even court overstepped into like something like a judicial activism, or maybe what is not mentioned explicitly in the Constitution. The court, the judges found merit in that and came with such a mechanism or doctrines.
That's a view that some people take. Some people think it was judicial activism and a judicial coup by which the Keshavanand Bharati case was decided. I think not. I think it's the fundamental philosophical thought that every idea and every concept has a core which cannot be changed if you want that idea to remain in existence. So if you take a human being and you take a man and you convert in terms of anatomy and in terms of physiology and in terms of functionality, you turn the man and change the man's sex into another sex, he would not be a man anymore. Now there are a few things you can change. By letting a man grow his hair long, or letting a man maybe get rid of extra hair, etc., doesn't change him from a man to a female or to a woman. But there will be certain elements of physiology that change would mean that he is no longer a man, right? And therefore, if you want to keep him as a man, you'll have to say you can't touch the following elements of physiology. This is a basic concept in psychology, it's a basic concept in philosophy, it's a basic concept in constitutionalism, and that's basically what it's about. It's not about somebody saying, well, I'll just declare a man as a woman. It's not that. It's not, that's could be judicial activism. This is actually a discovery of the truth of an idea, the truth of a concept, or the truth of a document.